Hello, I'm Bridget.
I'm Brandi.
And this is the Brandi and Bridget Show. So, as you all know, you love our webcast. And today we are going to discuss a case.
Our case is called Rosenblatt versus Baer.
During our Rosenblatt versus Baer case, we will be discussing the IRAC method, which are the issue, the rule, the application, and the conclusion.
Enjoy the rest of the show. Bye.
Bye. Well, not bye. More like, see you later.
See you soon. Yeah.
The Belknap County Recreation Area was mainly a ski resort, but other recreational activities were held there as well. People protested against the respondent and the commissioner, stating that they had not developed the area's full potential for the county's taxes. The petitioner regularly contributed to an unpaid column at the Lacona Evening Citizen, where he commented on political matters and disagreements with the actions taken by the respondent and the commissioners. Here are some of the petitioner's comments in the paper. The petitioner's comments follow. Been doing a little listening and checking out Belknap Recreation Area, and I'm thunderstruck about what I am learning. This year, a year without snow till very late, a year with actual very few major changes in procedure, the difference in cash income simply fantastic, almost unbelievable. On any sort of comparative basis, the area this year is doing literally hundreds of % better than last year. When considered the last year was excellent snow year, the season started because of more snow months earlier last year. One can only ponder the following question. What happened to all the money last year? And every other year? What magic has Dana Bean and the rest of the commission and Mr. Warner wrought to make such tremendous difference in net cash results? The respondent alleged that the column contained defamatory falsehoods concerning his performance as supervisor. The respondent offered extrinsic proof and had two theories. The first theory was that the jury could award him damages if it found that the column cast suspicion and discrimination on the small number of persons who composed the former management group, whether or not it found that the imputation of misconduct was specifically made of him concerning him. This theory of recovery was open to respondent under the New Hampshire law. The trial judge explicitly instructed the jury as an imputation of impropriety of a crime to one or more of a small group that cast suspicion upon all its actionable. The question is presented, however, whether that the theory of recovery is precluded by our holding in the New York Times that in the absence of sufficient evidence that the attack focused on the plaintiff, an otherwise impersonal attack on governmental operations cannot be utilized to establish a libel of those administrating the operations.
Precedent for our case, Rosenblatt versus Baer, is New York Times versus Sullivan. The plaintiff Sullivan sued the New York Times, which is the defendant, for printing an advertisement about the civil rights movement in the South. The ad was filled with small factual errors.
Stating the law for New York Times versus Sullivan, a federal rule prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with actual malice. Analyzing the facts in sight of the law. Although the advertisement did not mention the plaintiff by name, he claimed that it referred to him indirectly because he had oversight responsibility of the police. The jury found the ad libelous and actionable without proof of malice. The jury awarded the plaintiff $500,000 in damages. Under Alabama law, a publication is libelous if the words tend to injure a person in his reputation or to bring him into public contempt. In conclusion to the New York Times versus Sullivan case, the U.S. Supreme Court reversed the decision ruling that Sullivan could not recover damages in this case unless he proved that the New York Times published the false and defamatory advertisement knowing it was false, or that the paper exhibited reckless disregard for the truth when it printed the material.
The second theory was, even accepting respondents' readings, the column manifestly discusses the conduct of operations of government. The subject matter may have been only of local interest, but at least here where a publication was addressed primarily to the interested community, the fact is constitutionally irrelevant. The question is squarely presented whether the public official designated under New York Times applies, also in the Garrison versus Louisiana case.
In the precedent of the Louisiana versus Garrison case, Jim Garrison made statements against the judges of the Criminal District Court of the Orleans Parish regarding their lack of good judicial conduct on the job. The case centers on those accusations of Mr. Garrison in which he claimed the judges to be lazy, taking too much vacation time, and allowing pending criminal cases to pile up. When stating the law, a state court convicted him of violating the Louisiana criminal defamation statute. The state Supreme Court affirmed the conviction, holding that the statute did not unconstitutionally abridge the appellant's freedom of expression.
In conclusion to the Garrison versus Louisiana case, it was then appealed to the Louisiana Supreme Court, which ruled in a conservative direction that stated that the earlier decision be affirmed. Precedent review. Garrison versus Louisiana. You cannot recover damages for defamatory comment about official conduct unless proved actual malice, that such comment is made with knowledge of its falsity or with reckless regard of whether it is true or false. New York Times versus Sullivan. Since New York Times had not been decided at the time of the trial of this case, respondent should be allowed to adduce proof that his claim falls outside of the rule of that decision, or that petitioner's comment was made with malice as defined therein. And on retrial, it would be for the trial judge in that first instance to determine if the proof show that respondent was a public official.
The issue is whether the column contains defamatory falsehoods concerning the respondent's performance as supervisor of the Belknap County Recreation Area. According to the rule, the First and Fourth Amendments, a state cannot award damages to a public official for defamatory falsehoods relating to his official conduct unless the official proves actual malice that the falsehood was published with knowledge of its falsity or with reckless disregard of whether it was true or false. Application. The New Hampshire Supreme Court affirmed the award, finding the New York Times case no bar, granting certiorari and requested the parties to brief and argue, in addition to the questions presented in the petition. Also, whether the respondent was a public official under the New York Times and Garrison versus Louisiana cases. In conclusion, the New Hampshire Supreme Court awarded respondent damages in the civil libel action based on one of the petitioner's columns in the Lackawanna Evening Citizen.
Well, that's the end of the show.
We hope you enjoyed it and learned something.
Because we certainly love showing it to you. So the next media law case that we will be analyzing to you will be
Colorado versus Bryant 2004. See you then.
Bye.
Thank you for watching.